What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to be reacting to Alan Jackson / Karen Read / Karen Read's other defense attorneys' reactions after the big hearing in the civil case where they announced that they're going to be filing these civil charges against law enforcement, against the McCabe's and Alberts, etc., people inside 34 Fairview. And they discussed the motion to dismiss some of the emotional distress claims. And it's always kind of fun to see what the lawyers are saying outside the courtroom, because after I just took time breaking it down, telling you my thoughts, they get to tell you how they think the hearing went. Were there any surprises? Why did they do things the way that they did? And you can also learn, what are they trying to drive home to the public? What is the reason and the purpose for what they're doing in court and what they're saying now? Because when you have microphones in your face and media covering your case, it is an important aspect to working to fight for justice for your client. And if you're not thinking about that, you're not being purposeful with these interviews, then you're not fully representing your client. So we're going to take a listen to what they all had to say right after court. And make sure you guys hit the like button. Make sure you're subscribed to our page. Let's get to it. All right, so the first person to walk up here, it's kind of funny. It's Karen Read, and she doesn't really say a ton, but they come up, they ask her questions, they swarm her, and let's take a look at kind of the questions they have for her, what she says, and then when Alan Jackson pops in, he, of course, has a lot to say. I think I still have it. Oh, no, I don't have it sped up.
Poor girl. You need a bold statement tactic, right?
I think we're a little offensive during the criminal trial.
How does that work?
I need a fallback.
He said something about, is this a tactic? I don't really know what he meant by that. And then she said, I need a fullback. So looking for Alan Jackson, her protector. If I'm Alan Jackson in this situation, I love that she said that and did that, because she feels very confident and comfortable that you are going to protect her in these moments as her lawyer, right? There's all sorts of different kinds of protection, obviously, that somebody can have. But this is an important one. All right, let's take a listen to what he has to say.
Y'all didn't even let her get a blocking back.
You're not even let her get a blocking back. You know, I'm a sucker for sports analogies.
Alan, can you help me understand what an affirmative claim is? What an affirmative.
Can you help me understand what an affirmative claim is? And the reason for the question is, we know what a claim is, right? That's a complaint. You file it against somebody, you claim they did something, and you go to court on it. We know what an affirmative defense is. We talked about that yesterday. It's a defense that you actually have a burden to prove as the defendant. You have to provide discovery that shows you can prove this affirmative defense. And if you don't provide any discovery and there's no reasonable argument you have for it, the judge can dismiss your affirmative defense almost as if it's a claim on your own. So if they're saying their affirmative defense is that there's a third party that's actually responsible, which again is an affirmative defense, but they provide no evidence that there is a third party responsible for it, the judge can throw that out and not let them argue it in the civil court, which sound familiar, right, from what happened in criminal court. But this is something more than an affirmative defense. And you can have the third party responsibility as an affirmative defense and also a complaint against a third party, which is a claim. So an affirmative claim, I don't know, maybe it's a little different in Massachusetts. That's not verbiage we use in the law often, that it's an affirmative claim, but it would just be a claim or a complaint against a third party complaint. But they're using this affirmative claim, I think, if I'm just going to give my suspicion here, I think they're trying to use it to try and weave it together in the judge's mind to be like, it's kind of like an affirmative defense, judge, and so connected to this case that we need it to be connected to this case.
It's an affirmative claim against the third party.
We are also going to give a lot of grace to Alan Jackson, who is admittedly just a criminal lawyer, just like I'm just a civil lawyer. That's just a joke. But his verbiage is going to be, he's going to rely on his co-counsel for a lot of the verbiage and what happens in civil litigation. And folks, it doesn't matter, right? When you go and you argue a case, you know the rules of evidence, and you're a trial lawyer, you can learn how to do it in lots of different areas of law. I just tried my first probate litigation case ever and absolutely loved it. And I would never have been able to do it without my amazing co-counsel who knew all the probate rules backwards and forwards. And when it came to court and arguing the rules of evidence and cross-examining witnesses and making arguments to the judge and keeping evidence out, I felt right at home, right? Because it doesn't matter. Civil, criminal, probate, don't even matter. You get in there and you do your job. So the question was, is this like a counterclaim? And he's like, well, no, because it's not a counterclaim. Then he's like, well, yeah, it is kind of like a counterclaim. And it's like, it's not a counterclaim. It's a third-party complaint, which he's trying to use this verbiage. And by the way, in case anybody didn't notice, and if you're new here, I'm going to be talking a lot throughout this interview because everything they say is going to be really important for us to pick up on and learn what's happening and why it's happening. So the reason you want to call it a counterclaim, even though it's clearly not a counterclaim, as opposed to just a completely separate complaint, is again, their goal in this interview is going to be to connect Karen Read's offensive claims as much as they can with her defensive claims so that we can keep them all in the same courtroom because that's cheaper and easier and better for Karen Read. And there's more transparency in the state courts than there is in the federal court. So he's going to call it counterclaim, use whatever verbiage. In reality, it's a separate complaint you're trying to join in and consolidate with the current litigation that's going on. But that makes it sound like two separate things you're asking the judge to bring together as opposed to something that already should be together.
No, it's a counterclaim.
What the claim is?
What an affirmative claim is, it's an affirmative claim against the third-party individuals. That's exactly what we intend to bring.
But the idea is to get them combined to save the court time and money.
All the same individuals are involved, so that's exactly right. It's a matter of judicial economy.
So all the same individuals are involved. If I'm the O'Keefes and I'm their lawyer, and I just had a wrongful death claim, which again, we talked about the missteps he made with the whole conspiracy and lying and making up a story and involving a blogger named Turtle Boy and all that stuff, how that's just a mistake for them because it opens the door to a lot of this. But if I was the O'Keefes and I just filed a wrongful death car accident claim that she hit John O'Keefe with her car, I think I have a very good argument that all the same people are not necessarily involved. And I can use the car, I can use some interviews, but law enforcement's investigation, maybe I would downplay it a little bit. And I would definitely try to separate myself as much as I possibly can from law enforcement. Now, the defense, the pesky rules of evidence that allow you to do things and rules in litigation and rules that promote justice in the interest of justice, they can bring in and say, no, it wasn't her, it was somebody else affirmatively, and we can prove it with all these other people. And bringing all those other people into her defense make them inextricably intertwined to where they might all actually be one case that we can argue together under one court case.
Well, of course, because it becomes a bigger case, more voluminous, right?
The question was, is it going to take this judge longer to handle this case if he does add all these in? Answer is, of course, yes. It is going to make this individual case longer, but if you take judicial economy as a whole, and if we were to have this case as it is and a completely separate federal case, those two cases together would be way longer than if we just combine them one here. So overall, judicial economy would be helped, even though this individual case would be definitely more difficult and harder. But I would argue if I'm Karen Read's team that it's not really going to be that much longer and that much harder, Judge, because we're bringing all this crap into this case anyway. We're going to be deposing all these people that are third-party defendants. We're going to be accusing them of things and proving that they did wrong throughout and that they stepped on Karen Read's rights and that they conspired against her. We're going to try to bring all that in and prove all that. So how much longer is this case really going to be?
It's a bigger case with more claims. And that's exactly what this case calls for.
How did you determine
the days of Karen Read being on the defense are over?
And that's going to be the quote they want to go away from this interview. And you can always rely on Alan Jackson and this defense team that they're going to give you some quotables. And the days of Karen Read being on the defense are over. Now, we've already heard they were pretty offensive during the criminal case, proving things and really knocking out some of the prosecutor's arguments. But now she is actually going to be the prosecutor herself on these civil claims that she has against the current and former law enforcement officers and the people inside 34 Fairview.
Right? That's what started today. That's what we're seeking today.
What do you think of the judge say trying to resolve this? Can you resolve this out of
Every
court?
single civil case should at least have that on the table. Civil cases are built and designed to be resolved if they can be. We'll see.
Anybody surprised at that response? I'm going to back it up so we can hear it again. He's like, what did you think about the judge saying you should try to resolve it? And Alan Jackson, he's learning civil quick, right? Every civil case should have that on the table, meaning a mediation. Most jurisdictions force you. You have to go to mediation before a judge will even give you a trial date. They're like, if you're not even trying to work this out, come on, this is about money, right? Even if you disagree with what happened, right? This is about all you can get is money at the end of the day. So Karen Read, instead of paying $100,000 in lawyers and experts, if you offer them $100,000 and this thing goes away, then we all go away. Now, she doesn't have to do that. The insurance company doesn't have to do that. You can maintain your innocence clearly and never settle a case. but cases settle for all sorts of reasons. People get older, people get sick, people don't want to deal with litigation anymore and they just want it to be over, so they'll take less or they'll pay more depending on what side they're on. So there are all sorts of reasons civil cases resolve. And Alan Jackson says he doesn't really seem to have a beef with that. And I think that's great, as opposed to being hyperbolic saying we'll never settle no matter what, which I'm sure we will hear and I'm sure it will be said, and it may even be true. But what if the O'Keefe said, give us $1 and we'll go away? Do you think Karen Reed should settle? I would say yes. And I'm sure people are going to disagree with me about that. And people are probably going to get angry with me about that. But for $1, and I would say it's not going to be a confidential settlement. I want to tell the world I paid you $1 to go away, and they can make whatever decisions they want to make and presume and assume whatever they want from that. I'm going to maintain my innocence. I'm not going to ever admit I did anything wrong. But if I don't have to fight it, and I don't have to go through this stress and money drain on my life, and I can move on with my life for $1, I'm going to settle it. And who knows if that happens? It's happened before, I will tell you. I have had cases, again, I don't defend insurance companies, but I've defended some individuals from time to time, and I've had cases settle for $500 where the people start asking for $5 million at the beginning of the case.
Trying to resolve this, can you resolve this out of
Every
court?
single civil case should at least have that on the table. Civil cases are built and designed to be resolved if they can be. We'll see. We'll see. It depends on how reasonable the other side.
And you know what he said there that was interesting? Civil cases are built and designed to be resolved. What does he mean by that? You're going to hear lawyers throughout this case. You're going to hear motions. You're going to hear hearings. You're going to hear interviews where you're building leverage. And this is something I love about, the civil world is, and it's kind of like poker. I play the man more than the cards. I'm not like a genius poker player, counting cards and stuff like that, but I've always been pretty good. I usually just play with my buddies, not like, go and do anything crazy. But if you have leverage and you feel the leverage, you use the leverage and you win with the leverage, right? It can be anything. It can be fantasy football trades. You're like, they need this position. I don't really, maybe I can capitalize here. Sell high, buy low, whatever it is. When you feel like you've got the leverage in civil cases, there are moments throughout the case where I'm like, oh, my case is really good right now. And then they call me and I'm like, oh, hello, let's talk. Then there are some points in the cases where I'm like, oof, that wasn't great. Maybe a bad deposition, maybe a bad explanation. Maybe something happened where it's like, oh, this is going to be misconstrued or twisted, whatever it may be. Something outside of your control. That's not when you want to settle the case. And that's when you explain to clients, now is not the right time. So there's all sorts of leverage building throughout the civil case that provide opportunities for settlement. And most civil cases, that's how it is. This is going to be a little different than your average civil case, obviously, but he's right. That is how civil cases are basically built and handled.
Are built and designed to be resolved if they can be. We'll see. We'll see. It depends on how reasonable the other side.
Depends on how reasonable the other side is, right? This doesn't sound like take it or leave it, zero, we're never making an offer. But at the end of the day, there's also, if you drop claims against us, we drop claims against you. Sometimes I've had that happen where no money even exchanges hands. And they're like, listen, let's both walk away. Neither of us have to pay each other anything. That's not going to work for this case because they're not countersuing the O'Keefes. If they were countersuing the O'Keefes, that brings that on the table as a potential settlement. Listen, we don't have to pay each other anything. You go away, I'll go away. We shake hands and it's over. Neither of us admit any wrongdoing. That happens a lot. But here, who are they suing? Tully, Buchanan, Proctor, McCabe's, Alberts, etc. So why would the O'Keefes say, yeah, we'll waive our lawsuit if you waive the lawsuits against all of them? How does that work? That would be interesting, wouldn't it? Who's protecting who here? I don't think Karen Reed should or would go for that. But that's not normally how we both waive each other's claims. We waive attorney's fees and costs. So you can't come after the victor sometimes gets attorney's fees and costs. The prevailing party, you can waive things like that to settle cases. It's all about leverage. It's all about, like he said, building and handling cases to settle or to resolve.
You guys would like to,
If they can be. We'll see. We'll see. It depends on how reasonable the other
was
the
that
other
something
side
that
is.
you guys would like to do though? I mean,
Say it again.
was that something that you guys would like to do, or do you seem to want to make a point?
Anytime there is a civil case, look, civil cases are not about making a point. They're about trying to seek the truth, right? And that's what
Civil cases are not about making a point. What does he mean by that? Because it certainly feels like they're trying to make a point, right? And I think a lot of the world thinks it's exactly what they're trying to do here. They're trying to make a point. I think, if I could be so bold, what he means is if they'll give you what you want, whether it's $1, whether it's shake hands and everybody walk away, whether it's an apology. We have negotiated all sorts of things in civil cases. Because if you're willing to walk away I've had clients that will take less money if they get a handwritten apology. Like, okay, if that's what you want. Or they get some possession back or whatever it may be. And what Jackson's saying is if you get what you want, why keep going forward just out of principle to keep beating their brains in because we know we can, right? I'm very, he would say, very confident. I'm going to go win. I make people nervous. I don't get nervous. But if you get what you want in a civil case, why continue going forward? Resolve it, settle it. Who cares what everybody else thinks? If that's what Karen Read wants and that's what's best for Karen Read, then that's what you do.
Is that something that you guys would like to do, or do you want, you seem to want to make a point? so-
Anytime there is a civil case, look, civil cases are not about making a point. They're about trying to seek the truth, right? And that's what Karen's going to do with this civil case. We're going to try to get the truth out there. Like I said, the days of her being on the defensive, those days are over.
So you said,
She said civil cases are about seeking the truth. I couldn't agree more, Mr. Jackson. Couldn't agree more. And he couldn't have been kinder in our text exchange, by the way. He's like, listen, I didn't mean you, man. Come on. And I was like, I know. But it's interesting, right? Now that they're on the offensive, civil cases about seeking the truth and proving the truth, not just about money. Now, there certainly should be money involved here. If Karen Read is successful in proving these civil claims, she is absolutely entitled to money and she should get money. So should her lawyers. That's how it works, but it's about seeking truth and justice. Couldn't agree more with him there. Even though I disagree with some of his other characterizations of plaintiffs, lawyers who file claims like this.
And then everything, by the way, everything that you heard in there was basically parroted. Every single word that you heard in there was basically parroted right from Michael Morrissey, right from the prosecutions. They lifted it right off the prosecution's closing argument. And maybe somebody should check the tapes. Because last time I checked, those arguments were put forward in front of a jury, and the jury spoke very, very loudly. Not guilty, and not just not guilty when the jurors were asked, innocent. Those claims are false, and they were proven false, and they will be proven false again.
So again, no lack of confidence, which is not a surprise. And to me, and there's no way he could have seen this because he was sitting in the hearing, but so many people were commenting that during my live and during the hearing and afterwards in the rewatch crew. That's one of the most common comments I got, which is, why are they saying all these things as fact? These have been proven that they're not true. These have been proven that these are not the facts, that these are the opposite of the facts. I don't get it. And he's leaning into that. Again, the public and a lay person's view of what happened in court, I agree with. It's like, what the heck? How can this guy stand up there and say this stuff as it's fact? They already lost. And that's the res judicata argument, that something has already been adjudicated. But it only works when it wins in the higher burden. So if beyond a reasonable doubt, if they would have proven these things as fact in the civil court, the preponderance of the evidence, it would already be seen as true. And they could say, Judge, we want you to take judicial notice of this conviction, and all these facts are true against Karen Read. But it doesn't work on the inverse, where the state did not prove these cases beyond a reasonable doubt. And that's why it's always so important that we remember all this stuff builds off each other in the law. So that's why I tell you guys, people aren't found innocent. Yes, these jurors were given interviews and they said, yeah, I think she is factually innocent. Or if I had to say, I would say she is factually innocent. But that's not what they were there to decide legally. They were there to decide, is she guilty beyond a reasonable doubt or not guilty, which can be innocent or not proven, but neither one of those boxes are checked. It's just not guilty, which encompasses all. So because they were found not guilty and those claims were not proved beyond a reasonable doubt, does not mean that they're res judicata as not true and the facts are not true. He knows this 100%. But what he's saying is this is preposterous. They are following a losing argument. We all know it's a losing argument. We're not just going to win on the defensive side where, once again, we're going to show that they cannot prove this. Forget about beyond a reasonable doubt. They can't prove this by a preponderance of the evidence. But guess what? There's more. We're going to prove it. We're going on the offensive, and we know what happened, and we're going to prove what happened. So he knows the difference in res judicata, which is what's already decided, what's not. He knows that in a motion to dismiss, a judge has to. The judge is not choosing to take these facts as true for what the plaintiff is saying at this point. He has to. He is legally bound, right? Like in cuffs, he has to take these facts as true at this point in the decision he's making right now. But guess who doesn't? The jury. If we ever get to trial, the jury does not have to take those facts as true. The plaintiffs are going to have to prove these facts.
In terms of what you just asked, Should this case be resolved? We're always open to resolution. We'll see. We'll see. It depends on how reasonable the other side is.
Do you plan
And that's, I mean, we say that in every case too. And I have defense attorneys call me all the time, be like, hey, would you guys be willing to talk settlement? My answer is always yes. Always yes. And if my client says, absolutely not, I won't settle for any amount of money, I'm like, you got to think about it, because at the end of the day, the only thing a jury is going to give you money is money. So if you're not willing to take any money, what do you think the jury's going to give you? Now, of course, there are specific performance cases, but we're going to put those aside. And so we have the conversation like, hey, I realize this is very bad damage, or your mom or dad or son was lost. And I realize that's an impossible number or thing to put a number on, but that's what the civil justice system is for. And we've got to come up with a number here to at least give them, even if it's really high, even if they say no, fine. At least we came, at least we talked. We'll see how reasonable the other side's going to be. This is a great mindset to have as a civil litigator for somebody who's used to being a bulldog, and everything probably looks red to him, right? He's a bull. So he goes through and everything probably looks red, and he's used to just destroying everything in his way, or anybody putting up something that's hindering where he wants to go. But he's doing a great job already with the mindset of, hey, come to the table, be reasonable. It reminds me of my dad in civil cases, right? And sometimes I got to be like, settle down. Listen, we got to handle this the right way to where we're going to get the best result for the client, not just leave the other side picked dry, bloody, and bruised, because my dad will do that to the opposing counsel. But we want to make sure the client gets the best result.
We got to go.
Damon, did you want to say anything? I mean, you've been sort of point person on this, or?
Well, Alan says it all as in his perfect way. So
You have anything to say? He's like, well, Alan says it all in his perfect way. Thought that was kind of funny.
what we're trying to do is make sure that Karen is well defended, and that the claims that we have to pursue for her affirmatively are brought in the same proceeding
Again, the claims we're going to bring for her affirmatively
in the most efficient, judicious way.
for Karen Reed. This is definitely the most efficient, judicious way for Karen Reed. I would argue if I represented the O'Keefes or Proctor, Tully, those defendants, the third-party defendants, either side, I would say it's not the most judicious way, not the most economic way for either of those sides. I think it makes it more difficult for both of them, but it's definitely more economic for Karen Reed.
So that her day in court is fully and fairly adjudicated.
But if you combine these cases, isn't that unfair to the O'Keefes?
Not at all. Not at all. Part of her defense is that somebody else put her in this situation. And so that's when I said it's not your typical wrongful death action. Karen Reed is in this situation because of the behavior of others. And
he's fully in on that, right? Fully in on him. He's seen a lot more than we have, and they're going to prove it. They're going to try to prove it at least. And he says it's not unfair for the O'Keefes. Is it unfair? Is it unjust? That's something I think we got to think about. We got to talk about. We got to kind of see how it is. But legally, I think they are going to have arguments against this case, being consolidated all together.
as Alan said,
They being the O'Keefes.
she's no longer on the defensive. She's going affirmatively. And we're trying to put all the evidence, all the parties, all the claims in the same proceeding.
How did you decide on who to name in the counterclaim?
I'd love to tell you that, but it's really sort of a litigation strategy point.
How did you decide who to sue? I'd love to tell you, but I can't.
So unfortunately, I cannot get into sort of discussions behind the scenes.
So do you plan to prove that someone else killed John O'Keefe?
We plan to show that Karen did not.
But that's not the same as proving someone else did.
We
I would agree. It's a great question. Are you going to prove someone else did? We're going to prove Karen did not. So let's talk about this. If they prove someone else did, that's a much higher bar than just there was a cover-up, there was a conspiracy, they all got together to pin it on Karen Reed. Doesn't necessarily mean we're also going to prove that one of them with whatever last name actually did it. And frankly, I've said this from the jump and people didn't like it. The investigation was so deplorably bad that I don't think anybody can ever prove what actually happened. Like in a court of law. Preponderance of the evidence may be easier, but no way ever beyond a reasonable doubt could you ever prove who actually did this. So I actually like this strategy and this answer because I think it's a lot easier for them to prove that Karen Reed didn't and all of these people did things either intentionally or negligently to try to pin it on her versus proving who actually did it. Because also proving who actually did it doesn't help as much as what they did to Karen Reed. But will the public be satisfied? Will that just be something that's told in a movie or a book versus in the court of law? What are we actually going to see in the court of law? It sounds like we might not see an explanation of who did it and what exactly happened. Now, we still might, but I just thought that was an interesting answer.
And to show that Karen did not.
But that's not the same as proving someone else did.
We're going to let the evidence play out. I'm not able to tell you that yet, but I can tell you that she did not.
How about, can you spell your first last name for me? Colin?
Sure. Damon, D-A-M-O-N, Seligson, S-E-L-I-G-S-O-N.
Thank you.
All right, I should probably remember his name, Damon Seligson. Okay, I mean, only a lawyer could turn a 3.5 minute interview into a 25-minute YouTube video. But so much happened and so much to pick apart and so much to learn from this. And I know you guys had so many questions of this and you guys sent me this, which I always appreciate. Thank you so much. I love reacting to and breaking down lawyer interviews specifically. That might be one of my favorite things to do on YouTube. So what can we learn? What are they trying to do with it? Let me know what other questions you guys have, what I didn't answer here. Let me know your thoughts if you agree or disagree with whatever I may have said there. But that's all we got for now. Thanks for coming. Thanks for joining. Make sure you hit that like button. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe.
You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com.
And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.